Okay, here we go, part 3.
Yeah, I think there is a brief from the social scientists that addresses this, but this law has been in place for over 100 years, starting at a time when the law was.
I think slavery was around and okay for a lot of years too, but that was okay to change that. But when it comes to guns, if it stops freedoms to possess a gun and it's been around for a long time, then it must be a good thing. They're such hypocrites in the liberal left.
Not as well understood in this area as it is now, and so it's a little bit anachronistic to talk about before you put this law in place you should have evidence. But I believe there is evidence about the success that New York has had in keeping
success. How many shootings and crimes and violence and gun crime does they have there with criminals using guns that are in a revolving door of their shitty court system and their sanctuary city, allowing illegals in there by the hundreds of thousands? And they're saying it's successful? Really? See, it's just amazing. You could just lie with a straight face.
In keeping gun violence down that is attributable.
Taking a gun from a law-abiding citizen does not reduce crime. Law-abiding citizens aren't committing the crime with guns. They've got guns to protect themselves from the criminals that are committing the crimes.
To the reduced number of guns that are being carried, particularly in these densely populated places. So,
General, one of the things that strikes me about this area is that on the one hand, it seems completely intuitive to me, and I think to many people. If you think about Justice Thomas's questions about less populated areas, the rural areas of New York versus the cities, it seems completely intuitive that there should be different gun regimes in New York than in Wyoming?
Yeah, of course it does, because you're a freaking tyrant. Because you're a left-wing liberal woman that thinks you, as government, are smarter, and that you think if we pass laws restricting good people from guns, that idiots will believe that really keeps them safe. That's why you're an idiot.
Or that there should be different gun regimes in New York City than in rural counties upstate. But it's a hard thing to match with our notion of constitutional rights generally. Mr. Clement makes a big point of this in his brief about how we would never really dream of doing that for the First Amendment or other constitutional rights. Allow that level of local flexibility that you are basically saying we should allow in this context. So I guess I just want to hear you say why you think that is. What justification is there for allowing greater flexibility?
Well, I wonder if you would just say that slavery in rural areas, because they can't get help, should be okay, but in highly densely populated areas, we should restrict slavery, right? Because it's not that slavery is wrong. We're just going to make it wrong in highly densely areas, right? Is that what you're saying? Because you're a freaking idiot?
Here.
Well, I think one point is that there is a very wide range of sort of distribution of rural and urban and different kinds of areas, not just across the whole state, but within counties. And so delegating the decision-making with appropriate criteria to somebody who is local, which is what this is. These are local judges. In most of the state, they're judges. To make the relevant fact findings, to make the relevant inquiry. This is an interactive process in which these individuals and others are told, I'm not going to lift the restrictions now, but if you come back, if you have more to say about this, feel free to come back. It's an ongoing process. It's one reason why there isn't so much appellate litigation, is that that is what happens. So it's hard to see how you could specify everything in advance and have it be a clear on-off switch and still take adequate account of, on the one hand, the need for self-defense, and on the other hand, the strong public safety concerns. And that's why.
So I like the way she wants to argue about it's an ongoing process when you have to prove to us that you need a gun and you can keep coming back. However, we want red flags laws so when somebody says you shouldn't have a gun, government can take your guns and then you get to come in and tell us why you should get them back. It's just amazing, the liberal lunacy.
I think this system.
I don't think that was Justice Kagan's question.
Oh, I'm sorry.
It was on a broader level, I believe. She can correct me if I'm wrong. The issue is no other constitutional right do we condition on permitting different jurisdictions to pass different regulations.
Correct.
But do we have any other constitutional right whose exercise in history has been as varied as gun possession and use?
Well, I think that's right, both at the level, the local level, and at the state-to-state level. We have a strong history here of a range of responses from state to state that is based on local conditions and local concerns. And what we have within New York is an effort to recognize we have almost the same range of different kinds of spaces within the state, and this is the effort to accommodate that. And if the history warrants taking local conditions and local population density and so forth into account, it's hard to think of another way to effectively do that. There is, after all, appellate review available here, all the way to the central, to the highest state court.
Thank you, counsel. Justice Thomas, anything further?
But let's just take, for example, hunting. That's something I think we can agree on. You can't hunt I'm sure, with a gun in Central Park. But I'm certain that there are places in upstate New York or even in western New York where you can. I don't
Including Rensselaer County, yes.
Yeah. So I think what we're asking is if that you can have that difference for the purpose of hunting specifically, why can't you have a similar tailored approach for Second Amendment based upon if it's density in New York City?
First of all, Second Amendment has nothing to do with hunting.
If that's a problem.
Okay, the founders did not just get back from a hunting trip when they said, hey, let's make it all right for people to have guns so they can hunt. The founders made the Second Amendment number 2 is because we just got finished fighting a tyrannical government that wanted to take guns and disarm the people and were shooting and being tyrants. That's why the Second Amendment was put in, not from a hunting trip.
On the subway, then you have a different set of concerns in upstate New York.
Well, hunting permits work for particular locations, for particular areas, but it's all one statewide regime. I mean, and so too here, licenses are handled locally. It's not exactly the same, but it's the same model that licensing of handguns.
This woman who's arguing, this attorney, she doesn't even sound like she's convinced at what she's saying. She's like, I'm not real sure, and I'm thinking, maybe if and buts of coconuts and
to carry a handgun for self-defense is handled locally under a single set of criteria, but with reference to local conditions. I think that's right.
Justice Breyer?
Are we considering here just the
left-wing idiot.
upper state New York law? We're not considering New York City, are we?
I don't see any reason to be considering New York City.
Okay, so it's not in the case.
Petitioners are not from.
They're not.
See,
Okay,
yeah.
all right. Now, if you're trying to get uniform.
He just tried to circumvent this ruling that the ruling applies to only outskirts of big cities. That's not the case. But that's what this little left-wing pink panty, pink tie wearing weasel just did.
Doesn't the First Amendment, isn't it filled with local statutes use the word may, parade permits, event permits? So
Yes.
It's not special. Can you
Correct.
think about...
So he's arguing for her because she can't argue her case. He's making points and then letting her verify.
In the areas where permitting happens, which includes First Amendment areas, it could be parades, it could be solicitation for charity. There are various areas where First Amendment activity is
So what I'm driving towards, and I thought also there is a brief here, I think it's the social scientist, remember the name of it, which says in instances where, and they do it statistically, they are more liberal in allowing people to carry concealed weapons who are good character people.
How do you consider good character people? Because you're a judge? Because you're a cop? Because what? Because I can show you judges who were arrested for child molestation, child porn, rape, beating their wives. I can show you cops that are arrested for all that. What is your definition of good moral character? Okay?
And there is a greater risk of a crime or harm where that happens. There are more deaths of innocent people. Now, what is that brief? I'd about like to go back and look at the figures.
Yeah, I believe it is.
It's funny, there's been no deaths of Supreme Courts. Oh, I forgot. You guys have special rights. You get to carry. You can't go around you without going through a metal detector, and you have armed people following you around. That's why there's no deaths or murders on the Supreme Court. Shocking how that works.
A brief of social scientists, but
All right, I'll find it.
Yeah.
But do you think it's useful to, were we to have a trial, could we go into that? I mean, I think the great problem would be, fine, let's have some absolute rules, uniform national rules. I'm not sure we have those in the First Amendment, but assume we do. What are they? What are those rules?
well, I think they would end up being factors that have to be taken into account because the range of situations.
Anything that restricts government control, government wants to have factors that are taken into account so they can avoid, dismiss, and water down the Constitution, which restricts government. And government hates it.
Is so different both on the need side, on the public safety side. So I think it's very hard. In fact, that's one of the things that I think is hard about the suggestion that a sensitive place regime could replace a system like this.
Or if you had a guess on how many concealed carry licenses are given in the area under consideration, upstate New York or outside of New York City, in a given year or around, any way you want to put it, are they in the tens of thousands? Are they in
I can't do it statewide. I have statewide estimates.
Yeah. Estimates. That's not facts. That's something that you made up to support your case. And you call it an estimate, so when they find out you're full of shit, you can say, well, it was only an estimate.
Not estimates. I have permits for Rensselaer County and for statewide. It would be possible to get more, but I don't.
Are they rough? What are they?
This is in footnote 10 of our brief. In the 2-year period, 2018 to 2019, in the state, there were approximately 37,800 grants.
I get the rough idea.
That is 2 years in New York. 37. Cut that in half. You got less than 20,000 a year for New York City that gets granted. Do you have the numbers that you denied? Because that's going to be in the hundreds of thousands.
And if, in fact, it were remanded, I guess we could go into that in more depth.
That's correct. That's correct. We have the grants. Of course, there are licenses that weren't granted in those years that are still valid, so that doesn't tell you how many licenses there are out there altogether. The thing we had to estimate was the grant rate because we don't have application data. We had to estimate that from other information, but we have the permits.
Justice Alito?
You think any of these people would be for, if the state wants to limit we need to limit the state to where they can only deny 10% of the people that apply. So, you have to pick the 10 worst that you think don't need to get it. Otherwise, you have to issue everyone else. You think they would be okay with that? Of course they wouldn't. They don't want anything that ties them down or locks them in to being fair.
Is it correct that the non-speculative standard applies throughout the state? It applies equally in New York City and in the most rural location in upstate New York?
Well, it has been the law has been interpreted to mean that, although the experience of granting licenses, or the experience with license applications, is that it is apparently more readily satisfied upstate.
So the individual officers have a degree of discretion.
Well, yes, they're asked, like judges on many issues, they are asked to take into account certain factors. They can be reversed if they took.
Oh, so they're like judges. Why don't we have judges do it?
The wrong factors into account, or if they failed to take the specified factors into account. It's not unguided discretion, but it is discretion in the sense that.
What guarantees, if any, are there in your regime that a licensing officer is not taking into account improper factors?
I mean, this is a question about the judicial system generally. If he correctly records the factors that he.
If a frog had wings, he wouldn't bump his ass when he jumps, but he don't, and he does.
Took into account. They write letters or opinions, which may or may not fully disclose. One assumes will disclose what they thought was important. When often they're not just the papers, but there are if he denies a license, he will say why. He has to say why.
We've been presented in your brief and all the other briefs in this case with an enormous amount of history, citations to all sorts of statutes and other sources. Would you be willing to concede that maybe you got a little bit overly enthusiastic in your summary of some of the historical sources that you cited in your brief?
Okay, he's about to zing her, so she better be careful.
I'm going to give you.
We did our best to be accurate.
That means I lied. We did our best to be accurate. Losers are always whining about their best.
Reporting what we reported. I don't know what you have in mind.
Yeah, well, I'm going to give you an example, which is, it's troubling. I can see how it would slip through. I'm not accusing you personally of anything, but
yes, you are, and good for you. I'm glad you are.
On page 23, you say that. In founding era America, legal reference guides advise local officials to, quote, arrest all such persons as in your sight shall ride or go armed. And this is a citation to John Haywood, a manual of the laws of North Carolina, 1814. So I looked at this manual, and
that means one of his clerks looked at it and showed him.
It actually says is you shall arrest all such persons as in your sight shall ride or go armed offensively. And somehow that word, offensively.
Which means you lied to push your point, and you lied about other things, and you're unethical, and you will do anything to get the guns because you're a left-wing communist freaking traitorous piece of crap.
Got dropped
from
your brief. You think that's an irrelevant word?
I think it would have been better to put it in and make an explanation, but I do think it's an irrelevant word because we have substantial authority for the proposition that guns were deemed to be offensive weapons. And that's why we have this dispute about whether saying, there are different ways of putting it, offensively or with offensive weapons or to the terror of the people. These either describe a separate characterization, a separate feature that not all weapons have. That's my friend's position on this. Or they describe the belief that all such weapons are offensive.
Well, if that's the case, then all government is out there being offensive and terrorizing people because government has guns. Our military, our cops, the people that guard U.S. Marshals, federal agents, ATF, B&E, you name it, they all have offensive and they're terrorizing people. That's what she just said. No. See, this is where it doesn't apply to government. It only applies to you pesky citizens.
Well, I don't want to belabor the point, but of course if any possession of weapons outside the home was illegal, then there would be no need to put in the term offensively, the inclusion of that.
Well,
term.
there are many other weapons. Usually there's a list that's it's not in this particular instruction, but there will be a list of weapons. They were talking about much more than guns, and it was guns that were said over and over again to be offensive.
All right, well, thank
weapons.
you. Thank you.
But that's the explanation.
She's lying. Whatever. He knows it. She's not going to submit. You freaking lie. Now, one of the liberal left wings will come in and give her a softball question. Ready? Get her back on track and build her confidence and say something that helps her. Here we go.
Justice Sotomayor? Justice Kagan?
You started a thought and then you were taken off someplace else, so I just wanted to
That means the other justice, the mean Second Amendment justice, interrupted you and didn't let you finish. And I want to get you back because I think you were going where I wanted you to go.
allow you to finish the thought. What you said was that there was a reason why a sensitive place regime cannot serve as a replacement, and then you were not given an opportunity to say why.
Because the mean man justice who likes guns cut you off. Go ahead and say it, you little left-wing commie.
So why?
Well, essentially because there are it would be very hard in the first instance, and I think also not very acceptable in the to my adversaries in the second instance, to specify in advance all the places that ought properly to be understood as sensitive. So it sounds like a very convenient alternative. But, for example, we were talking about Times Square on New Year's Eve. Times Square when the theater district, when commerce is in full swing, Times Square almost every night is shoulder-to-shoulder people. So then you end up having a very big difficulty in specifying what all the places are that have the characteristics that should make them sensitive. It has in principle it has an attractive quality to it, but in implementation I think it would be unsuccessful.
Justice Gorsuch?
No further questions. Thank you.
Justice Kavanaugh?
No, thank you.
Justice Barrett?
I have one. General Underwood, do you think Heller was rightly decided?
Oh.
I think there is a lot of support historically and otherwise for it, so I'm quite content to treat it as rightly decided. I think.
What do you mean you're content? It's the freaking law. The Supreme Court ruled it, and now you're trying to weasel out of it. Just say you don't agree with it because it gives people a right to have guns in their homes.
There was an argument on the other side, too, but that's true about maybe most of the difficult questions that come before this Court. I have no quarrel with Heller.
Do you think that we are bound by the way that we characterized history in that opinion? You know, Mr. Clement has pointed out that in some respects the way that we treated, say, the Statute of Northampton and is different from the way that you argue that we should interpret that and the follow-on, statutes in the colonies. You argue that we should understand those in some other cases differently than we did in Heller. Are we free to do that?
I think you are, because I think the Heller decision made very clear that it was not deciding anything other than the right to keep arms in the home. In the course of arriving at that decision, it necessarily said a lot of other things that led to that decision, but I don't think they are controlling, or I think the opinion itself says we're not trying to do a full exegesis of the whole Second Amendment right, and there's more to be done, and it would be odd and really inconsistent with general practice to treat every sentence or every reference to a historical source as controlling for all time. as distinguished from for the purposes for which it was invoked.
I actually kind of think she did all right on that answer.
Thank you, General.
Thank you, General.
Consistent with the Second Amendment because it is firmly grounded in our nation's history and tradition of gun regulation. Now, as Justice Alito said, there's a lot of history floating around this morning, and so I want to be clear that when I say that, I am putting to the side all of the disputed bits about the Statute of Northampton, about the surety laws, and I'm putting to the side laws that restricted concealed carry but did not restrict open carry. And I am focusing on laws that either prohibited or required a showing of good cause to carry a concealable weapon like a pistol. Tennessee enacted one of those laws in 1821. Texas followed in 1871. New Mexico and Arkansas likewise enacted such laws in the years immediately after the ratification of the 14th Amendment. And over the decades that followed, more than a dozen other states enacted other laws that were at least as restrictive as New York's. Like my friends from New York, I count about 20.
I don't have any damn friends in New York. I don't want any damn friends in New York. Although there's probably some conservatives there that I could be friends with. Most of you are a bunch of left-wing idiots.
Laws in total that fit that description. Those laws remain in force in 7 states today, and more than 80 million Americans live under their protection. They are, in short, both traditional and common regulations. I'd welcome the Court's questions, or I'm happy to continue.
How do we determine which states we should look to? You focus a lot on Western states, but the West is different.
I agree, Justice Thomas, and I think there might be reason to be skeptical about a tradition that's only reflected in one state. I think that's a problem for Mr. Clement in relying on some of the cases exclusively from the antebellum South. But the cases that we're relying on come from the South, like the Tennessee, Arkansas, and Texas law I described. West Virginia had a similar law, as did Alabama, New York, Massachusetts, California, Hawaii. The tradition that I am drawing on spans 2 centuries, going back to the Tennessee law. It spans 150 years when you broaden it out to many states, and spans all regions, or virtually all regions of the country. So I think that's the sort of tradition that you can look to when defining a national tradition of gun regulation.
But, I mean, what is the appropriate analysis? I mean, I think generally don't reinvent the wheel. I mean, the first thing I would look to in answering this question is not the Statute of Northampton, it's Heller. And Heller has gone through all this stuff. And obviously in a somewhat different context, although that's part of the debate, self-defense at home, this is different. But I still think that you have to begin with Heller and its recognition that the Second Amendment, it has its own limitations, but it is to be interpreted the same way you'd interpret other provisions of the Constitution. And I wonder what your best answer is to the point that Mr. Clement makes in his brief, which is that, for example, if you're asserting a claim to confront the witnesses against you under the Constitution, you don't have to say, I've got a special reason. This is why I think it's important to my defense. The Constitution gives you that right, and if someone's going to take it away from you, they have to justify it. You don't have to say when you're looking for a permit to speak on a street corner or whatever that, your speech is particularly important. So why do you have to show, in this case, convince somebody that you're entitled to exercise your Second Amendment right?
So let me start with the general question and then get to that specific point from Mr. Clement. As to the general question about Heller, we agree completely that the Court ought to apply the method from Heller, which we, like I think all the parties, take to be look to the text, history, and tradition of the Second Amendment right, and we're applying that now to a somewhat different issue with the benefit of somewhat broader.
Let me make it clear for those people that don't get it. If the left had it way, they would remove the Second Amendment right. They don't want it. They don't like it. It's a pain in their side. All tyrannical governments hate when their subjects are armed.
Materials. Now, as to the question about why do you have to have a showing of need, I think the problem with Mr. Clement's formulation is that it assumes the conclusion. If you had a right, the Second Amendment conferred a right to carry around a weapon for possible self-defense just because an individual wants to have one available, then obviously you couldn't take away that right or make it contingent upon a discretionary determination. But the whole question is whether the Second Amendment right to keep and bear arms confers that right to have a pistol with you for self-defense, even absent a showing of demonstrated
I'm not
need.
sure that's right. I mean, you would regardless of what the right is, it would be surprising to have it depend upon a permit system. You can say that the right is limited in a particular way, just as First Amendment rights are limited, but the idea that you need a license to exercise the right, I think.
It's funny the founders didn't put the First Amendment shall not be infringed. It's funny that they only did that on the second.
It is unusual in the context of the Bill of Rights.
So I agree with that, but I think I heard even Mr. Clement in response to a question from Justice Kavanaugh say he doesn't have a quarrel with licensing regimes in general. And I think what that is one illustration of is that the Second Amendment has a distinct history and tradition, and that the way to be faithful to the Second Amendment is to be faithful to that history and tradition and not to draw analogies to other rights with their own histories and traditions.
Well, there's licensing and there's licensing. Maybe it's one thing to say we need to check, make sure you don't have a criminal record, make sure that all the other things you can check on, but not that we assume you don't have a right to exercise your.
I'm sorry, I'll probably piss some people off here. I don't even think you need a background check for a weapon. I think that's bullshit. If the government thinks that you should not own a gun, the burden of proof is on the government. If they think you have a record, then they have the right to run your criminal history and prove you have a record. It should not be you having to prove you don't have a record. It's bullshit.
So I guess
it's hard to say it without saying it, with exercise your right under the Second Amendment, and you've got to show us that you do.
So we would ask that question by looking to the history and tradition of the Second Amendment. And in Tennessee in 1821, you couldn't carry a pistol at all. In Texas in 1871, you had to have a showing of need if you were going to carry a pistol. And that showing of need was actually
the hell was Texas thinking back in 1871? Bunch of damn liberals moving in already.
Much less favorable than the New York regime. In Texas, in West Virginia, and in Alabama, in those laws that we cite, need to carry a firearm was a need that you had to show when you were prosecuted for violating the law. It was essentially a self-defense requirement, and you had to persuade a jury in a criminal trial that you had an immediate pressing need to be carrying the gun when you were carrying it. The laws, of which New York's is one, but by no means the only example, that began to become more prevalent in the 20th century, said, we're going to make that determination of need ex ante. We're going to require a showing of good cause. New York has done that for a century. I'm sorry, Justice Kavanaugh.
This might be a level of generality issue, but I think Mr. Clement responded to some of what you're saying on history and tradition by saying you have to look at carry laws more generally. And there was open carry traditions in a lot of those states. And so that I think he followed up by saying, so open carry is one option, shall carry permit regimes for concealed carry another option, but what you can't have is no open carry and simply a may-issue discretionary regime that will, in practice, he says, limit the right. So can you respond to that?
Yeah, I meant to be taking that into account in the account of history that I'm giving you. So the Tennessee law refers specifically to carry publicly or privately. Texas, the same story. If I were here defending a regime that just prohibited concealed carry and allowed open carry, I would have many, many, many more states. But I'm focused on just this type of law, and even there, our submission is there's a substantial history and tradition of that kind of regulation. It's not the sort of outlier that the court confronted in Heller and McDonald. And if I could speak to, Mr. Clement has spoken some about the case law from the 19th century and has suggested that laws like these were struck down. And with all respect to my friend, that's not correct. The cases that he has
I hate that he calls the enemy my friend. My enemy is not my friend.
Relying on are primarily dicta. The two cases he has that actually struck down laws, the three cases that he has that actually struck down laws are the Nunn decision from Georgia, which struck down a law that was banned even the keeping of pistols. The court did say in dicta that open carry was required, but the law was actually much more restrictive than that. The Andrews case that he relies on and that Heller relies on as well is actually more helpful to us because the court upheld a prohibition on the carrying of belt or pocket pistols. And it prohibited a ban on revolvers only because the court construed that ban to be so broad that it would prohibit even carrying it around your house. And in the very next sentence, the court said, but of course the legislature, if it wanted to, could regulate the carrying of that firearm publicly. And then when you turn to laws like the ones that we have here, which include some sort of self-defense exception, either ex ante or ex post, the trend in the cases is in favor of upholding their constitutionality. We've cited about 6 decisions from the 1800s and the early 1900s, including the Duke and English cases from Texas, the Isaiah case from Alabama, the Haley and Fife cases from Arkansas, and the Workman case from West Virginia, all of which upheld those laws. And Mr. Clement's answer to those decisions is that they rested on the erroneous understanding that the Second Amendment or its state equivalents protected only the right to use arms in the militia. But that is not what those cases say. They do not stop by saying that the defendants were not militiamen and so had no rights. The Texas cases in particular, in Duke and English, say that the law makes all necessary allowances for self-defense by including the type of exception we described earlier. And so our submission is that that body of case law that New York law carries forward is part of our nation's history and tradition of firearms regulation, and that New York ought to be allowed to continue to make the choice that it has made. And we understand, and there's force to Mr. Clement's argument, that other states have made other choices. Justice Alito made powerful points about how some individuals have a powerful claim to have a gun for self-defense. But the question before the court is, of all of the different approaches to these difficult issues that states and other jurisdictions have taken over our nation's history, is this one that the Second Amendment takes off the table? And our submission is that when it's an option that New York has and other states have had for a century or more, and that traces as far back as some of the laws that I've been discussing into our nation's history, that's an option that is consistent with our tradition of gun regulation and is an option that ought to be available to the states.
Justice Thomas? Justice Breyer? Justice Alito?
Is it correct that the Sullivan Law was an innovation when it was adopted?
It was relatively new. I think the Sullivan Law was 1911. The licensing requirement at issue here was 1913. I think Massachusetts had done something similar in 1906. Hawaii did its as well in 1913. And we view those as lineal descendants and, in fact, improvements upon the sort of Texas laws, which made you prove self-defense at the back end rather than giving you a chance to demonstrate it up front.
There's a debate about the impetus for the enactment of the Sullivan Law. Is there not? There are those who argue, and they cite support for this interpretation that a major reason for the enactment of the Sullivan Law was the belief that certain disfavored groups, members of labor unions, blacks and Italians, were carrying guns and they were dangerous people and they wanted them disarmed.
Pretty much what they're saying today. Liberals think black neighborhood violence is out of control and gun violence in black neighborhoods is out of control, but they don't want to say it because they'll be called racist, so instead they would rather penalize every legal gun owner in order to get rid of the guns from black people. I've said it 1,000 times. Gun control is the most racist thing out there, and nobody wants to address it.
There have been those arguments made, and there's certainly evidence that those sentiments existed in New York at the time. I have not seen things that persuade me that those were the impetus for the Sullivan Law, and to the extent that that was a question, I think the fact that similar laws have been enacted and maintained, not just in New York and not just at that moment in time, but in a number of different states throughout the country, throughout large swaths of our nation's history, is a good reason to believe that this is not just prejudice, that this is a legitimate regulation.
I really wish some group would start a mantra that I don't think black people should have guns, so I'm for gun control. Let's get a bunch of people promoting that and tweeting that and see how quick the left backs off from this gun control racist shit.
I think one more question about the major point that you've made this morning, which is that there are scattered statutes, local ordinances, judicial decisions from various points in the 19th century, extending into the 20th century, the early 20th century with the Sullivan Law, and the other laws that you mentioned that are inconsistent with Mr. Clement's argument. But what does that show about the original understanding of the right that's protected by the Second Amendment? Would we be receptive to arguments like that if we were interpreting, let's say, the First Amendment or the Confrontation Clause of the Sixth Amendment? Would we say, well, you can find a lot of state laws and state court decisions from the 19th century, early 20th century that are inconsistent with a claim that is made based on the original meaning of a provision of the Bill of Rights, and that shows that's what that was understood to mean at the time.
Well, Justice Alito, I think Heller was receptive to those types of arguments and conducted a review of history through the 20th century, and rightly so. I think it's not unusual to look to the nation's tradition to understand the meaning of constitutional rights. I think that's especially appropriate here for a couple of reasons. One is that I think everyone agrees that the right codified in the Second Amendment is a right that is subject to some reasonable regulations, and in deciding what regulations are reasonable, we think the fact that they've been prevalent throughout our history is a good sign that they are. We think that's especially so because of a point that this Court made in McDonald, which is that throughout the nation's history, this is a right that's been recognized and codified in state constitutions as well. It's not something that people were not aware of. And so the fact that this type of regulation coexisted for so long with that understanding, we think is a particularly strong indication of its consistency.
Well, Heller, and I will stop after this, Heller cited decisions going into the 19th century as confirmation of what it had already concluded based on text and history at or before the time of the adoption of the Second Amendment. It said this is what it was understood to mean at the time, and it's further evidence that this is what this right was understood to mean because it kept being reaffirmed by decisions that came after. But I find it hard to understand how later decisions and statutes, particularly when you start to get into the late 19th century and the early 20th century, can be used as a substitute for evidence about what the right was understood to mean in 1791 or 1868 if you think that's the relevant date.
So you're certainly right about the way that Heller looked to decisions on its core holding of does the Second Amendment protect only a militia-focused right or an individual right. But when Heller turned to the question presented here, which is what sorts of regulations are consistent with the right that it was recognizing, I think it's fairly read to extend the analysis into the 20th century for the reason that Justice Kagan identified, that it validated as presumptively lawful felon in possession requirements, bans on the possession of firearms by the mentally ill that date to much later than the 19th century.
Thank you.
Justice Sotomayor?
What do you do with Heller and its recognition of categories of exclusion? Mentally ill, felons, domestic violence, presumably, although it didn't mention it.
Because you're going to keep adding to it. That's what government does. It starts out as, we just need common sense gun regulation against mentally ill. We just need common sense gun regulation against felon. We just need common sense against domestic violence. We just need common sense against populated area. We just need common sense about Times Square. We just need common sense about... It never ends.
Can any of those ever pass scrutiny on their face?
I don't know. I think the lesson from Heller, though, is that you don't need to apply strict scrutiny or any other level of scrutiny because those are the types of regulations that are validated by our nation's history and tradition of gun regulations. And so we would take that lesson from Heller as exemplifying the proper mode of analysis and apply it here as well.
So what do you do with the view, Mr. Clement's view, that the essence that Heller says is that you do have some sort of right outside of the home to guns for self-defense. So how do you finish what you think that right is? Or how do you describe it?
Ask me how to describe it. Shall not be infringed. Pretty freaking easy. It ain't that freaking hard.
So we don't quarrel at all with the notion that the Second Amendment has something to say outside the home. Our submission is just that to understand how it applies outside the home, one has to look to the history and tradition of regulations. And what we've tried to argue in our brief and this morning is that there is a substantial history and tradition of the regulation of the public carrying of concealable weapons.
I want you to notice how much faster this guy talks. Subject matter experts talk faster because they understand the subject matter and they grab information quickly. When you listen to the other freaking general that was discussing about this, she was stammering and talking slow so I can pull and try to figure out how to manipulate and change what I want. That's the difference between subject matter experts and posers.
Including pistols, because of the dangers that they present, and that regulations of that type, of which New York's is one, are consistent with the right recognized in the Second Amendment.
How about, let's go to the extreme. There's no exception for a good cause. There's no exception for no exceptions whatsoever. No rifles for hunting, no nothing. Outside the home, you can't possess any kind of ammunition-driven weapon.
Perfect. That falls right under shall not be infringed.
Yeah.
Where would we be with that?
I think that is a type of regulation that fortunately no state has today, and that I don't think there's.
Why did you say fortunately no state has? You little frickin' weasel.
Any historical precedent for. I don't think you could make this sort of argument for that sort of
give
law.
me the limiting principle of.
See, this is how the left gets you into these little conundrums where you don't know what the hell you're saying, and you don't have conviction in what you believe, and now you give them an inch, and now they're going to get you to agree to some bullshit.
What regulations and how far they can go that don't achieve that.
So see, she's got him now about to argue for the other side.
Right. So I think, like Mr. Clement, it's going to be difficult for me to give you definitive answers because, in our view, this is an inquiry that has to be driven by history and tradition, and that requires a careful examination of history and tradition. But let me give you a couple of guideposts. I think there is a tradition of laws like the Tennessee law that I alluded to earlier and others that prohibit the carrying of concealable weapons without any exception for self-defense or
perfect.
Or any good cause exception like the one that you have in the New York law. So we think, and Judge Bybee for the en banc Ninth Circuit concluded after an exhaustive historical analysis that those types of regulations are consistent with the Second Amendment. But I acknowledge that that's a tougher historical case to make than the case that you can make with respect to laws like New York's that include self-defense exceptions.
Thank you.
Justice Kagan?
Mr. Fletcher, I think I probably should have asked General Underwood this question, but I forgot, so here you are. And the United States also has law enforcement officers, even though they operate differently from sort of the cop on the beat. But I'm just wondering if there is anything that you can say, any evidence that you can share. Are there studies? Is there information about how this actually affects how getting rid of this regime in the way that Mr. Clement would want this court to do? How it affects policing? How it affects the ability of police officers to keep the streets safe.
The officers don't keep the streets safe. You idiots have already ruled that police have no duty to protect and no duty to act. And now you want to, when it doesn't fit your, because if you say that, most people might have a light come on and go, holy shit, if the cops don't have to protect us, why the hell would we give up our guns? But you idiots don't want to admit that.
And how it affects their own safety. Is there information?
Oh, here we go. Officer safety. Their own safety. We got to worry about officer safety. That's why we let 19 kids die in Uvalde school shooting. We let 19 kids die while 19 officers stood in a hallway with Supreme Court protection saying they have no duty to act. And now 19 kids are dead. Yeah, that's your officer safety, lady.
Mr. Fletcher, I think I probably should have asked General Underwood this question, but Mr. Fletcher, I think I probably should have asked the cop on the beat. Affects how getting police officers to keep the streets safe.
I think the best place I can point you to for studies are some of the amicus briefs, including the social scientist brief that Justice Breyer discussed with my colleague General Underwood. In terms of sort of the United States' perspective specifically, I don't have any sort of quantifiable statistics. What I can tell you is that we do share the concern behind the New York law, which is the concern that having more guns on the street does complicate and increase the danger inherent in citizen law enforcement encounters. We do think that's a real concern. And it's
maybe law enforcement shouldn't be encounter citizens. Maybe law enforcement should stay the hell out of shit and not treat every citizen with a gun as if they're a criminal.
Real concerns that are reflected in the law that New York.
I mean, do police officers stop people in the same way in notwithstanding whether...
This is a paper tiger argument. When I was working, the streets in California cops that weren't from Texas, didn't understand Texas right. Their big thing was, how the hell do cops work in Texas knowing everybody's got a gun in their car, man? How do they even go to work each day? It's so scary to think that you'd have to go to work with everybody with a gun in their car. Meanwhile, there's more California cops getting killed than Texas cops because good people have guns in Texas. This is a paper tiger argument, and anybody that falls for it falls into the category of an idiot.
There are, whether it's a New York regime or a more permissive regime.
I apologize. I don't have studies on that. All that I can give you is my own sense that if I were a police officer, I would certainly think prominently in my mind about what are the odds that the person that I'm stopping or approaching on the middle of the highway, late at night, is likely to be armed.
Well, that's because you're not a cop. Because I don't really give a shit about that. I'm more worried about, is the guy I'm stopping a criminal or a good guy? Because if he's a good guy, I'm glad he's got a gun. See, that's because you're an idiot and you don't understand it.
And the licensing regime in the state is going to be an important factor in the risk that that's the situation.
This is why we can't have tinted windows in Texas. Freaking the hottest damn state around, freaking sun cooks everything. Government and police can have tinted windows, but because police are scared of cars with tinted windows, our freaking dumbass legislation passed laws that says regular citizens can't have tinted windows. Government can. They can get protection from the sun and shade and cool, but citizens can't because it makes police uncomfortable. We're going to start passing laws when government gets uncomfortable. That's exactly what the Constitution does. The Constitution is not to make government feel comfortable. It's to protect citizens from tyrannical governments.
Thank you.
Justice Gorsuch?
Mr. Fletcher, in your brief, you suggest that the New York law passes both the text and history approach and intermediate scrutiny. Should we apply that? And I guess I'd like to pose the same question to you that I did to Mr. Clement, and that is, what is the appropriate test between those two or others? The lower courts seem very divided over how to approach Second Amendment questions. Some apply the text and history approach to the challenge before them. Others say, yes, text and history is appropriate, but we're not going to extend to the Heller right until and unless the court first does so through its own text and history analysis. We're not going to do it ourselves. Others have applied intermediate scrutiny. Others have applied what might be described as a watered-down version of intermediate scrutiny. And some have suggested strict scrutiny or some modification of it should apply. I'd just be grateful for your thoughts.
I appreciate the question, Justice Gorsuch. And I think our view is that courts ought to follow what we understand to be the lesson from Heller, which is that you start with text, history, and tradition, and when those sources provide you an answer, one way or the other, either that the law is valid or that it's invalid, you end there, and that's the end of the inquiry. We take that approach to be consistent with the approach described by Justice Kavanaugh in his dissent in Heller 2. I think the one place where we might differ from him a little bit is that we think there may come a point, especially as when courts confront new regulations, where history gives out, where it's not possible to draw those historical analogies anymore. And at that point, our suggestion is that the way to be faithful to history and tradition is to look to the broader method that you find in that history and tradition, and the method that we find in a half dozen or so cases from the mid-1800s that we cite is to ask whether the law is a reasonable regulation. And as we explained in our brief, we think that the modern judicial method that is most faithful to that approach is a form of intermediate scrutiny.
Thank you.
Justice Kavanaugh?
Thank you. Mr. Fletcher, appreciate your focus on history and tradition and want to explore that and get your thoughts on one thing. As you say, there is a history and tradition, and it exists to the present day, of permitting regimes. And so the issue before us will have effects, but it's a narrow legal issue of shall issue versus may issue, and it'll have substantial effects. But there is a tradition of permitting regimes. But how do we think about, do you think, kind of a separate tradition that the Chief Justice and others have referred to in our constitutional law of concern about too much discretion in exercise of authority over constitutional rights, and that too much discretion can lead to all sorts of problems, as our history shows. So you've got the tradition of permitting, but how do we think about, fold in just a general concern about too much discretion?
So I appreciate that concern, and I think here's how I would think about it. First, I would say there is a substantial history of discretion in this particular area, starting out with juries in the Texas and West Virginia type regimes that I talked about now, moving into permitting officers. And I think that's inherent in any system. If you say a permit is going to be conditioned upon a showing that you have a genuine, specific need for self-defense, then someone's got to make the decision about whether or not you've made that showing. New York has decided it's best to do that by delegating the authority to local officers, local judges who are most familiar with local conditions. I do appreciate the concern about discretion, and I think if the court were to conclude that some sort of good cause, sort of self-defense-based exception is required, then the court might conclude that some more predictable or stringent or prescriptive guidelines are required, that you can't have that much discretion if the court concludes that that sort of good cause exception is actually constitutionally required.
Thank you. Appreciate it.
Justice Barrett? Thank you, counsel. Rebuttal, Mr. Clement?
This will be over.
Thank you, Mr.
minutes.
Chief Justice. Just a few quick points in rebuttal. First of all, I want to highlight that when the government was asked for its interest behind this permitting regime, it said that if it went to a different regime, it would multiply the number of firearms in circulation. In a country with the Second Amendment as a fundamental right, simply having more firearms cannot be a problem and can't be a government interest just to put a cap on.
Amen.
On the number of firearms. And that just underscores how completely non-tailored this law is. It might be well-tailored to keeping the number of handguns down, but it's not well-tailored to identifying people who pose a particular risk or anything else because it deprives a typical New Yorker of their right to carry for self-defense. Second point I want to make is just about population density. There's been a lot of discussion about that, but it's very much a double-edged sword because when there's a population density, that's an awful lot of people who all have Second Amendment rights. And so you can't just simply say we're not going to have Second Amendment rights in the areas where there's dense population. And I would say here experience does tell you a lot. By my count, 7 of the 10 largest cities in America measured by population are in shall-issue jurisdictions. And I've mentioned them, cities like Phoenix, Chicago, Houston. These are large cities where it hasn't been a problem. If you want to look at the empirical evidence, and I know, Justice Breyer, you asked about this, please also look at the English brief on the top side because it's a very rigorous statistical analysis that shows that as a matter of actually doing statistics right, there's no difference here. And what the only difference you really see is that people who have a handgun for self-defense end up with a better outcome.
Amen. Because if you don't have a gun in a gunfight, you lose every time.
They're not shot. They're not made victims. But the English brief, I think, is really worth taking a look at. I want to say a quick word just about permitting. There may be limiting permitting in other contexts, like parade permitting, but I'm not aware of any context whatsoever where in order to get a permit, you have to show that you have a particularly good need to exercise your constitutional right. And I think that is the absolute central defect with New York's regime here. I want to say a quick word about the history that my friend from the Solicitor General's office emphasized. It's telling that his first example is Tennessee. If you look at the Heller decision, Tennessee is a problematic state in terms of its history. The court gave that Tennessee Supreme Court first came out with the IMET decision, which the majority opinion in Heller criticized. It then came out with the Simpson decision and the Andrews decision, both of which protected Second Amendment rights, and the majority opinion in Heller praised those decisions at the same time that it criticized AMET. So to the extent there was an 1821 statute, I would put it in the same box as the AMET decision. Texas, which is their next example, and their only other 19th century example, if I heard my friend correctly, is even more problematic to rely on because Texas had a specific constitutional amendment that was similar to the English Bill of Rights but different from the Second Amendment that allowed the legislature to put specific restrictions on the right. So relying on 1871 Texas is highly problematic from a historical perspective, and that just leaves them with 20th century examples, which we concede, but by that point, the collective rights view of the Second Amendment was everywhere. Let me finish just by saying there's absolutely no need for a remand here. There are interesting statistics that could be developed, but none of them are relevant to the two central defects in this regime. First, that in order to exercise a constitutional right that New York is willing to concede extends outside the home, you have to show that you have an atypical need to exercise the right that distinguishes you from the general community. That
Total
describes
BS.
a privilege. It does not describe a constitutional.
Amen. But you know what? The government wants owning a gun to be a privilege.
Constitutional right. That is a sufficient basis to invalidate the law, but then there's the discretion. And the discretion here has real-world costs. If you want to look at it, look at the amicus brief in our support by the Bronx public defenders and other public defenders. The cost of this kind of discretion is that people are charged with violent crimes, even though they have no prior record, just because they're trying to exercise their constitutional right to self-defense. And if you want to know how this impacts policing, one of the way essentially making everybody in New York City a presumptive person who is unlawfully carrying is that leads to stopping and frisking everybody. The framers, I think, had a different vision of the Fourth Amendment and the Second Amendment, and that is that individuals get to make their decision about whether or not they want to carry a firearm outside the home for self-defense. In 43 states, people are able to do that. It doesn't mean everybody ends up carrying, and it doesn't mean that those 43 states have any more problems with violent crimes or anything else than the
Man, I like this guy. He's good.
6 or 7 jurisdictions that don't honor the text, the history of the Second Amendment, and Heller. Thank you, Your Honor.
Thank you, counsel. The case is submitted.
All
We
right.
will hear argument this morning
Good
in
deal.
case 20.
All righty. So, we'll end that there, and let me see real quick if they updated who voted. Okay, so that ends part 3. Now you understand how they got to their decision of 6-3. And you can tell by the questions that the left was going to vote no matter what the arguments were. All right, we'll end that there. Hopefully you got something out of it, and hopefully this can be shared with children to understand the evils of government when they say public safety, national security, and it's for the children. Those are all keywords to steal freedoms and to empower government to become tyrannical. We'll end that there.